Hello and welcome. My name is Peter Afrasiabi. I'm a partner at the law firm of One LLP. We are an intellectual property boutique with offices in Newport Beach and Beverly Hills, California. We specialize in intellectual property litigation as well as intellectual property prosecution, that is, the securing and acquisition from the government of patents, trademarks, and copyrights. The views expressed in this program are only my views. So, if you don't like them, by all means reach out to me and ascribe them to me. I take ownership of them all. Today's program is called Intellectual Property for the General Lawyer, Transaction and Litigation Pitfalls. The focus today really is on looking at the four major areas of intellectual property and understanding what they are and what they cover, and also what they don't cover. And one of the big issues that this program is built around today is looking at how you as a general lawyer, perhaps you're a transactional lawyer doing due diligence in a corporate transaction, or you're a generalist helping your client either acquire a business or sell a business. And in that realm, you need to understand when you are looking at assets and trying to figure out what assets exist or what may be there, you need to understand if you own assets or if you don't. And the way to do that is to have a proper understanding of intellectual property. And one of the overarching themes that you will see distill from today's program is that much of intellectual property law is not actually intuitive. It doesn't harmonize with the very basic standards we all know when it comes to real property in terms of acquiring assets, owning them, and knowing safely that you own them. And there are weird little quirks, we can call them, of intellectual property law that pop up, whether you're in copyright, patent, trademark, or trade secret, that can run afoul of your general disposition for thinking. And so today's program really is to identify those issues that really lurk there in terms of transactional problems that can go awry and create litigation exposure. And for me as an intellectual property litigator, I have seen many of these transactions explode and end up in litigation and see companies in positions that they never could have contemplated themselves being in, but they're there because there wasn't a robust enough understanding of the intellectual property legal overlay out of the gate. And so this program really is built around identifying those issues and helping you, when you do due diligence in transactions, make sure that you do your client justice and you don't make any mistakes. Along the way, of course, we're going to have tips and practice pointers so that you can avoid these litigation problems, so that you can actually and fundamentally increase the asset value of your client. You can protect the intellectual property, and you're going to have some good checklists for IP, transactional, and just for general, client health checkups and reviews if you're doing them with clients and wanting to make sure that they're in a good position vis-a-vis their intellectual property. So let's get going, and we're going to start with copyright law. Copyright protects original works of expression that are fixed in a tangible medium. One of the fundamental issues to understand when we're talking about copyright is that it's governed only by federal law. That is, federal principles on copyright define what it is you own when you own a copyright, how you can get a copyright, and what you can do with that copyright. And indeed, they preempt all state laws that fall within the vicinity of trying to regulate what would otherwise be copyrightable. So when we're talking about copyright, we are looking at original works of expression that are fixed in a tangible medium. So we can think of fantastic works like Van Gogh's paintings or amazing sculptures and the like, but we can also think about things such as perhaps you're listening right now and you're already bored and you're doing some really cool doodle and you're drawing it all up on the piece of paper as you're listening to me drone on about copyright law, and you are actually, you're creating an original work of expression and you're fixing it in a tangible medium, which is another way of saying you are permanently reducing it in some form. Your pen to paper is that fixation in a tangible medium. Now, what this means, of course, is that if you right now come up with the most incredible poem or haiku of all time that's going to make you a millionaire and you can retire from this practice of law, and you decide to put it up in the sky with a plane doing those kind of smoke messages in the air, and you put it up there in the sky, you have issued your work to the public, but you've not fixed it in a tangible medium. And so as of that moment, you actually don't have a copyright yet. So it does require a permanent recording of some kind. Not much, pen to paper suffices, but it can't be ephemeral like your haiku poem to your loved one in the air from the airplane. what types of things then fall within the realm of copyright? And the types of assets, we could call them, that you want to think about when you are doing due diligence into companies and you're trying to figure out, what copyrights may exist, or you're looking at a schedule of alleged copyrights and you want to figure out, could there be more? Are things such as books and other writings. And other writings is broad. Think about marketing materials, business programming ideas, and the like. Music, film, photographs, artwork, software and source code, very important one to think about. Architectural designs and plans can have federal protection at the copyright level. Even clothing designs, which have become a very big area in the last several years. Pantomimes, choreographs, plays, and the like. So it is a very, very vast realm when you think about it, and it makes sense because copyright protects any original work of expression that one has that they reduce to a permanent form.